we're still waiting to go up.
We are
live. Okay, good.
Curious.
And so we can get moving. This is Senate Finance. This is February 6th. And we are continuing our discussion of S-136, an act relating to amending the criteria of 30 VSA 248. And Annette Smith is with us. So Annette, the floor is yours, and we have your list. I did get it enlarged, of PUC cases that you had sent. So the floor is yours.
Thank you. My name is Annette Smith. I'm Executive Director of Vermonters for a Clean Environment. I thank the chair and the committee for asking me to come in today to go over the data.
She's frozen.
Yeah.
She's frozen. Then there's a seat up here. That's because the witness has really done it a long time.
Just like the good old days.
Yes. And that is frozen.
I don't know if anyone remembers.
I remember the Tim Ash days. And thank you.
There you go. You never know.
She's sits late in her long time.
She'll try to talk in a second.
Okay. I think she's connected.
Not yet.
We could go on. And when she can zoom in, we'll get back to her. If you think she's,
Sure.
okay,
Not currently.
not currently,
She's calling me.
he's calling you.
Yeah, hi. Well, your internet froze up. I don't know if you need to reboot or. Okay, hold on. I'm gonna put you on speaker.
Let her talk. Hi, Annette. If you, yes, can you just try getting again?
Tried 3 or 4 times and seems like this system isn't working.
All right,
Problem with my connection.
we had you for a while. We could check and see if we've got an outage.
No, we're still live.
Okay,
Maybe it's time.
there's been some issues with the
Same.
state house
Change.
internet Wi-Fi system,
And maybe.
but that shouldn't affect this.
Now it's, I got a link. Window
Okay,
occasionally opens and occasionally doesn't.
okay, I'm gonna leave you to keep working on this with Zane,
Okay.
and then,
Then I
Hi.
yes, and we will go on, and then hopefully we'll
Just take my
get
phone,
on
sorry.
before we're finished, or we will make sure we get you, okay? Okay, good. She hung. Go on. You're going back. Thank you. Okay. So, we will take Annette when she is able to get back into Zoom. We're going on to Ben Edgerly Wall. And then just introduce yourself and who you represent.
Thank you. For the record, Ben and Julie Walsh, the Vermont Public Interest Research Group. I appreciate you taking a minute to hear from us today on this issue. So I am going to skip over largely speaking to the climate crisis, though of course that's why we're talking about this at all. We're sitting in a city that has been flooded twice in the last 7 months. So obviously we all know there's a problem that needs to be solved, and renewable energy needs to be part of that solution. I want to start by briefly sharing my experience working on this, energy policy in Vermont over the past 15 years. And what I'm going to say, I want to be clear, is not just about the specific policy that's covered in this bill, though the topic that this bill addresses is absolutely part of this. It has been getting harder and harder over the last 15 years, my time, to build renewable energy here. It's not any one thing, but the sum total of the changes to policy in Vermont have, in my view, and I think this is a view echoed by many others, made building renewables more difficult than it needs to be, and more difficult than it used to be. And that's the same sort of opposition. Please.
Can you tell us what those were? Because not what policy changes were made here.
It's a host of things. When you look at some of the rules that the PUC has adopted, including related to the topic at hand today, but then it goes into the standard offer going away, which is obviously a totally separate policy. When you look at net metering and how that's been restructured to both reduce rates and to drive more development to what are called preferred locations, which are that the construct that we supported, building more parking lots and landfills and brownfields. Love that idea. The way it's been implemented, oftentimes the compensation for net metering is not adequate to actually get projects built in those areas. So again, it really is a much broader conversation about a number of different policies. What we're talking about here today is a slice of it. I think an important one, but only a slice. So the second thing that I wanted to just touch on briefly, and you've heard about this from others, is from our perspective, this is obviously about the climate crisis. It's also about environmental justice. And to the extent that we have policies here in Vermont that make it more difficult for us to build renewables, here that is policy that is inherently making it more difficult for us to move away from fossil fuels that are creating environmental injustices elsewhere. That's not to say that there is not an appropriate balance here, but that is a reality that we have to grapple with. Just one example to put a couple of numbers on how it has been getting more difficult. Just looking at the net metering program, because that's a program where numbers are pretty readily accessible. In 2018, just for projects from about 150 kilowatts, which is maybe an acre solar farm, up to a few acres, 500 kilowatt size. In 2018, there were 102 applications for projects of that size for about 31 megawatts. In 2019, that dropped to 72 for 16 megawatts. By 2023, we're talking about a dozen projects statewide for about 6 megawatts. So, we really have seen the pace of deployment be constrained. Again, that's not just about this. That also has a lot to do with the structure of net metering, but this is one of those factors. One other thing that I want to emphasize here is, in our view, this is a balancing act, right? You have two ends of a spectrum. On one end, anyone can build anything anywhere they want, anytime they want. That's obviously never happened in Vermont and never would, and nor would that be a good thing. On the other end of the spectrum, anyone who ever doesn't like anything can fully veto it. And that's obviously also not a real possibility. So we're somewhere in between. And the policy question is, what's the appropriate balance between deploying renewables, deploying affordable housing, deploying the things that have a really clear public good here in Vermont at the pace that is necessary to address the crises that we are trying to address with appropriate public participation and, robust consideration of the downsides of these kinds of projects, which do exist. So shifting into, what is the problem that is trying to be solved here? Obviously that's a question for the sponsor and for you all to decide what problem you're trying to solve. I think there's been an implication in some of the testimony that you've gotten that the appropriate problem to try to solve for is, are projects being rejected or not? And I would argue that that is too narrow a lens to look at this issue through. That it is not just projects denied, it is projects delayed, it is projects made more expensive, which when you're looking at project after project and a pattern of the projects being made more expensive, that is actually something that ultimately will increase costs for ratepayers. And you're looking at projects ultimately that never get applied for in the first place because there's a concern about putting a very substantial sum of money on the table. I let other witnesses speak to that in more depth, but my understanding is, for a project 150 kilowatts up to several megawatts, you're talking about, before you even get any chance of having, as you're sort of in the project development phase, you're talking about $50,000 to $100,000. A quarter to a fifth of that could be from aesthetics, not tree plantings, just literally the aesthetic expert that you need to hire, the designs you need to build to address the criteria. And you may have the rug pulled out from you on the other end. I know there are projects that developers would have liked to apply for that, never materialized. And that's not something that shows up in the PUC numbers. And I don't think anyone can quantify that with precision because you're trying to prove a negative. But it is part of it. It's a whole host of things, not just projects that go all the way to the end and then we're denied based on this criteria. The next thing I wanted to address quickly is some of the testimony you've heard about what this bill would or would not do.
Let me
Yes,
ask the
of course.
question. I think we're trying to find a balance between getting renewable energy up and running and at the same time having some protection for view sheds, neighborhoods, some input from neighbors. And we've been told only one has been denied on aesthetics. What I think I'm hearing is that allowing the neighbors to intervene slows the process down and costs renewable energy companies money. And these are for-profit businesses, right? And so where is the voice of the community if we cut that out? Or should the community not have any voice?
That's a great question, and I certainly am not arguing that. I won't speak for others, but that's certainly not our position. I think what you heard in testimony is there are, and this is actually where I was going next to my testimony anyway, a whole host of things that are being considered under Section 248. If it's all right with you, let me touch on what I was about to get to and then circle back to your question. You've heard from other witnesses that this quote unquote removes aesthetics from Section 248, that aesthetics would now not be considered under Section 248 if this bill were to pass. That is not accurate. That is not what this bill does. And that is not what I heard your legislative counsel tell you when this bill was introduced. There are two ways in which aesthetics comes into Section 248. One is the direct reference in the text will not have an undue adverse effect on aesthetics, historic sites, etc. That reference to aesthetics would be struck. It also incorporates by reference Act 250, which is 10 VSA 6080A8, which very clearly speaks to the effect on the scenic or natural beauty of an area, aesthetics, historic sites, or rare or irreplaceable natural areas. So this bill would change the way that aesthetics is considered under Section 248. It would not remove aesthetics from consideration under Section 248. And that, in my mind, is a pretty important distinction, that aesthetics would still be required to be given due consideration. It would not be in the the upper category of that sentence, requiring no undue adverse effect alongside air and water quality, natural environment, use of natural resources. And so to me, that speaks to sort of to the question that you just raised. What is the appropriate way for aesthetics to show up here? And as I read this bill, it would continue to consider aesthetics, but not make it quite as central to consideration under section 240.
Okay, so who would be considered under the new proposed language? Would that be the PUC?
The PUC would continue to be the entity that would determine whether or not the aesthetics criteria that is required to consider is violated by a project. The Department of Public Service also often retains an aesthetics expert to look at that. Obviously, this would restrict some of the other interveners and how they are some of the other interveners and the issues on which they're allowed to intervene, but it would not take that out. It would not remove consideration. And frankly, I think you would still have an appropriate public entity looking out for the aesthetics criteria.
Okay,
Under section
but
240.
no member of the community would be able to speak on that issue. It would be a board in Montpelier making a decision about a project up in East Overshoe without any, because the other criteria are traffic and public safety, right? I don't see those as being particularly difficult to meet. You're gonna have some traffic while you're putting it up, but after that, maybe visit it, I don't know, once every couple months. No traffic. I've read a couple things. There's no public safety and health access here. And I'm just trying to keep this balance between wanting them to go through, but also making sure that the voice of Vermont, of the people that's impacted, get heard.
Let me speak to that briefly, and then there are one or two other points, and I know you have other witnesses. The public would still be allowed to be heard through the 248 process. Whether or not a party is able to intervene is a separate question from whether or not they are able to weigh in or influence the process. Obviously, if you are an intervener, you have more influence, you have standing, and are a part of the process in a different way. But the Public Utilities Commission holds public hearings and takes public comment, and they're specifically directed in statute to use that public comment, those public hearings to, this is not a term that's used, but sort of to scope their work. And so if they are hearing a lot about aesthetics on a project, they are much more likely to, really give that a close focus. I would also guess, although you have to ask the department about this, that the department would then be more likely to retain an aesthetics expert to get to the bottom of the aesthetics concerns that have been raised. Last couple of things that I wanted to say. One, you've heard a whole host of concerns about this bill, that it would in some way jeopardize the, section 248's process of ability to look at water quality or flooding or natural resources or health impacts. And all of those things are still part and parcel of the section 248 process. Changing the way that aesthetics is considered does not in any way jeopardize the ability or the direction the PUC has to look at all those other criteria. And when you saw from another witness, mountaintops in China that had hundreds of acres of solar panels on them, that was not something that would ever be stopped in Vermont based on aesthetics criteria. That would not get the time of day. If you're looking at water quality, if you're looking at flooding, there are a whole host of reasons that testimony and the implication that may be where Vermont is headed was entirely inappropriate. And it has nothing to do with the aesthetics criteria. I will just note briefly, if you look at the things that are incorporated from Act 250, It's undue water or air pollution, including looking at headwaters, waste disposal, water conservation, flood hazard areas, streams, shorelines, wetlands, erosion, the capacity of water to hold land to hold water. And then again, aesthetics. I put a lot out there. Let me just back up and say, this in my mind is part of a broader discussion, including section 248, including Act 174 of 2016, which is an energy siting and planning law that this body passed, that has now been in place for a number of years, that was intended to create a more cohesive plan for how we're building out renewables around the state, and frankly, a clearer path to building out renewables in some parts of the state. I'm not sure that that is that goal has fully been met. And so as you're considering it, this bill, I think, all or parts of this bill are worth considering moving on their own, but it's also part of a much broader discussion about how we're approaching energy siting and planning.
I think I'm gonna try and set up a tutorial on the actual, what process, hearing a local PUC, what that process is, what interveners are, because several members of this committee have not been through that. I think it's all using portion. And then I think we'll look at Act 174 results. We'll take a look at that, see what's in there. Now, is that the bill that limited renewable energy to landfills and rooftops?
No,
That was the one I know we did that, no.
so what you're speaking about is the preferred locations construct, which was only incorporated in statute once, in a pilot program through the standard offer, which was sort of half utilized and moved on from, in the net metering rule, preferred locations, like you're describing, do exist. Act 174 was the law that required and regional planning commissions and allowed town or municipal planning commissions to do a higher level of planning for energy future and to gain additional weight at the public utilities commission. So that is what that was. Senator Gray, deeply familiar with that. You may recall that it was the bill that started as S230 and ended up in S260 in the veto override session that year. It's seared into some of our brains. Good. Thank you so much for taking the time to hear from me, and I'm happy to be part of this.
Senator Frost has a question.
Have you participated in PUC reviews of these kinds of projects previously?
We, VPIRG has monitored several section 248 proceedings. Most of my experience at the PUC is in their rulemaking or stakeholder process.
So you haven't testified in any of these?
No, I have not.
Participated, have you been to any of the proceedings?
I have been to proceedings. The one that we were the most actively engaged in, that our participation in went significantly north of monitoring, was the phase 2 of the Addison gas pipeline that would have gone to Lake Champlain. That's something that I very actively participated in.
Well, the reason, I read the bill and I thought through the key is the word aesthetics is lined out. And it says that it will not have an undue adverse effect on a number of things, aesthetics being one. So I own a piece of property. And next to me on that piece of property, someone comes along and builds a renewable energy facility that blocks my view, that covers that piece that's that half acre next to me in its entirety. And it's ugly, in my opinion. And with that lined out, what protection does that homeowner have to be able to deal with that situation if the word aesthetics is entirely lined out? Yeah, it may not have an effect on an historic site or where water and air purity or the natural environment. But boy, it's massive. It's as large as my house. It blocks my view. It's ugly. Everybody says it's ugly. Do I have no ability to do anything with that lined out?
So what I would reiterate is, if you look at that essentially long sentence, there's the wording before the comment and the wording after. Let me back up. And so the first several things that are referenced there in the text will not have an undue adverse effect on aesthetics, historic sites, air and water quality, natural environment, use of natural resources, public health and safety. So those are the things that, and you're gonna hear from the PC in a minute, so they can characterize this from their perspective. In very colloquial terms, I would describe those as the things that are sort of the most central to the section 248 review, at least this, subdivision 5 of it. And then if you go after that, comma, you have with due consideration having been given to the criteria specified in, and then it cites to a couple of things, most significantly Act 250 and 6086A8 is inclusive of aesthetics. That's the language, effect on scenic or natural beauty or the area, et cetera, that I read earlier. And so aesthetics would still be required to be given due consideration under this, but it would not, if that word were struck from the prior part of that sentence, be quite as central to the review of that. There are some things that are, the things up there are also incorporated in by reference, I think all of them by reference in Act 250 in the second part of the sentence. And so essentially by having aesthetics, again, to use sort of lay speak, in both places, it puts more weight on it. By removing it, it does not remove it entirely, but it removes that additional weight that having it in the first part of that sentence.
Well, all the other things remain at the same weight
The other things that are not struck,
that are not struck.
yes, if they are not modified, they would be, I would imagine, given the weight that they're given today.
And so you consider that to be of lesser importance, and so when this person produces and creates this half-acre monstrosity next to me, I have less weight for it to be considered by the PSP.
I do view aesthetics as less important than things like air and water quality.
Okay.
I do not view them as of no importance, which is why we're not asking for them to be removed in their entirety. But when we are weighing many different competing factors, things like air and water quality, environmental justice, and the climate crisis rank higher on the
But
list for us than aesthetics.
have you seen this abused in the process thus far?
I know you have heard from other witnesses about how this has been treated. From my perspective, it has been one of many contributing factors to the slower speed and higher costs of getting through the permitting process.
You mentioned somewhere along the line, an aesthetic consultant costing $150,000.
No, what I
misunderstand you?
maybe I spoke, maybe I was mumbling during that. What I said was, my understanding is getting through the permitting process, you're talking about 50 to 100,000, not
Okay.
150,000.
Mhm.
And that an aesthetics expert could be 10, 20, maybe $25,000. So a quarter to a fifth of the overall permitting costs.
You know that in prior things that have appeared before the commission, that folks have had aesthetics experts at that amount of money regularly employed?
That is my understanding. You can speak to other witnesses who directly employed them. The other thing that I would say, if I may, about this is, all things being equal, having these high upfront costs, which do not vary enormously depending on the size of the project, generally speaking, will tend to push projects to the larger size. So if you are going to spend, if you could build a 150 versus a 5 megawatt, but you're not spending 30 times as much money, you're more inclined to build a larger project. So to the extent that we have an interest in the state of having distributed generation, and that's a policy discussion and consideration, having a high upfront cost generally will make that less likely.
Well, this would produce a lower upfront cost then because you would not have to spend money for an aesthetic consultant.
I would argue that you would be less likely to have to spend a significant amount of money under the construct.
Well, consider the amount of money you're talking about, $10,000-$20,000 then.
Yes, that is my understanding of how much an aesthetics expert would
And
cost.
so again, if we line out any of these things, presumably it would be less costly to do the development.
Presumably, yes. Thank you.
Any other questions? Okay, thank you. And we have Annette Smith back. Let's hope she can stay with the duration. So Annette, the floor is yours. Just introduce yourself.
Thank you, and I will need to screen share. My name's Annette Smith. I'm Executive Director of Vermonters for a Clean Environment. I'm pleased to be here today. Thank you. Thank you for the opportunity.
Try again.
Oh, it is.
There are gremlins in this system, aren't there? All right, so
Larger than that, no one can do that.
I have shared my screen. Can you see it?
We can see it, but we can't read it.
That's okay. Do you have it in front of you?
Yes, we have it in front of it, and we can enlarge it there.
I will enlarge it, but at the moment I have it this size because of all the columns and how it shows up. I'm going to, as efficiently as possible, take you through what is here. The first column A, has the case number. Case numbers at the PUC are done first with the year and then with the case number. So this is in chronological order going back to the beginning of 2021. So this is 3 years worth of all the solar projects that I could find in EPUC from 2021, 22, and 23. The next number is simply the case number that's assigned in chronological order. The third identification is PET for petition, NMP for net metering petition, and there is also an NMR case in here, which is a net metering registration. If you do a search in EPUC for NMP or NMR, you get 2,000 cases. So while it was easy to get the petitions, it was not so easy to get the net metering cases. So I have had to do a lot of extra work to find those. Then we have the town in which the project's located. We have the acreage, which in some cases is put on the PUC's site, which is really great. And some cases I had to go into the PUC's order or even into testimony to find it. Some of these acreages are about just the footprint of the solar array, and some of the acreages are about the total limits of disturbance. So for instance, there's a project that is a 500 kilowatt project, but has 11 acres. And of that, only 3 acres is the solar array and the rest is generally forest clearing. The petition cases are all the megawatt cases. When you see 2.2, those are going to be standard offer cases. And then I set separate category for the 500 kilowatt cases. These are what are called group net metering or virtual net metering. And they're the ones that have been fairly problematic and are essentially, in most cases, not built next to load, are putting wholesale power up on the grid, and are getting the high net metering prices. The name of the company, and you'll see there are a finite number of companies that participate and do this. The developer attorney, again, a finite number of attorneys. The neighbor attorney, there are only 3 cases in these 3 years that have a neighbor attorney. There are a couple of cases that have utility attorneys there that Vermont Electric Co-op and Green Mountain Power have been joined to the case. I didn't add that category. Next, we get to public comment. And in the public comment category, we find that of the 67 total cases, 33 of them had no comments or interveners. The public comment is not part of the evidentiary record and cannot be cited by the commission in its decisions. Of the 16 cases had public comment, 51 cases had no public comment at all. The next category is Regional Planning Commission comments. And you may recall that the legislators have given the PUC the charge in these cases, in Section 248 cases, to give due consideration to the recommendations of the Regional Planning Commission, the Municipal Legislative Community, and the Municipal Planning Commission. So here I was able to document that the Regional Planning Commissions submitted comments in 17 of the 67 cases. Most of them were from the Rutland Regional Planning Commission. There were a few from the Northwest Regional Planning Commission, one from Central Vermont Regional Planning Commission, and one from Chittenden County Regional Planning Commission. What this shows is that the regional planning commissions are not submitting comments and not giving the PUC what they would like in terms of the information to base their decisions. Similarly with the town comments, there were 9 cases where the towns commented. Sometimes these comments were simply to say, we're fine with the project. Not a lot of these comments are substantive. The next is the town intervention. There were, in the 3 years, only 6 cases where the town intervened, and in almost all cases, all they did was monitor. And then the next category is for public hearings, and there were only 6 cases where the PUC held a public hearing, and I made a note that no public attended the public hearing. There may have been another one like that too. Site visits, there were 5 cases that held site visits that I've documented. I remember seeing 2 more, but I hadn't been tracking that when I started doing this, but there are very few site visits. There, in this whole listing, was only 1 evidentiary hearing. Now, there are some cases that are not resolved yet that I think a couple of them will have evidentiary hearings. There were, in this 3-year period, 0 cases denied. So we can then look at the cases that are pending and look at why they're pending. There is Randolph, a 500 kilowatt solar project. There's Norwich, a 500 kilowatt solar project. And there is this one in St. George, which has different issues. And then there is the Chelsea Solar project. Now, I'm going to stop sharing the screen so that I can talk to you about those projects. The 2 500 kilowatt projects in Randolph and Norwich are not really about aesthetics. They are more about orderly development of the region and compliance with the town plan, and also the manner in which the preferred site letters were obtained in the town. So there's been a lot of back and forth at the PUC about what happened at the town level getting the preferred site letter. And the senators who are on LCAR will know that we recently approved a new rule that will provide notice to the people who are required to get advance notices. And I believe that that will solve the problems that we've been seeing with getting these preferred sites submitted. Those cases also involve other issues such as, oh, I hear my solar hot water screaming. The sun is finally out and the tank is overheating. Both Norwich and Randolph have environmental issues. They have to do with lack of compliance with the town plan. And it is the neighbor interveners who are the ones that have been pointing this out to the PUC, and the towns have not done that. And so these cases show the value. The Bennington case has been denied once on town plan and aesthetics, denied a second time on single plan, and is back for a third time. And it is the people who live in the community who have stood up for the town plan, and the Vermont Supreme Court has issued a decision on a contiguous project on the same piece of land, finding that the project does not comply with the town plan and denied it on orderly development aesthetics. But nevertheless, the developer is back for a third time. So that other odd case, which is a net metering registration case, again, the members of LCAR may recall there was testimony by someone, and it has to do with adding capacity to an existing plant in a net metering registration. There is one very contested case that's been going on for quite a while. The PUC stayed all the rest of it until that was resolved. That case is actually a very important case, and I think opens the door for a larger discussion about what do we really want in Vermont. And for years, people have been talking about, we really need community solar. And that's what we're not getting. We've got this group net metering, which has been used in a way that was never intended. And what I would like to see is this legislature focus on real community solar. And in honor of Kevin Jones, who just passed away, he is the one who has been doing real community solar at Vermont Law School, and I'd like to see it dedicated to him. In terms of the expense of PUC processes, I have wondered for a long time why the developers haven't been screaming about it. I've watched hearings where I've seen the room full of lawyers and experts and think, you know, this hearing itself must be costing $50,000 to $70,000. I have put into the Act 174 working group, I suggested we move it to Act 250, which has a process where we could work collaboratively together. I have submitted proposals to that effect. Nobody ever talks about it. But as this legislature is very interested in driving development to our populated centers, that really is the place where solar energy should be built. And so if you want to look for regulatory waivers and exemptions, you might want to look at creating incentives to build in the built landscape, such as parking lots, which everyone wants, could save a lot of money and drive the development there. And I want to say something that I want to be really blunt about. We have a war going on in Vermont over energy siting. And I thank you, Chair Cummings, for this opportunity to bring it out in public and address it. And it's interesting that the legislators from Chittenden County are all in favor of this legislation. This war that's going on in Vermont is going on around the country and globally, and it is a rural versus urban war, where our rural areas are being asked to host technologies that then serve the communities that are in the urban areas. And solar is the one technology that can be placed in the urban areas and that can be done in a way that is compatible with our growth areas. So I am very interested in working with the industry, as I have done with other industries like Omia and Agrimark and JP Carrera and Sons, to find a way forward that brings us together, because I'm very sick of fighting over where to plant trees for screening and having it cost tens of thousands of dollars is ridiculous. We don't need to be doing that here in Vermont. But I have been targeted. The people I work with have been targeted. Neighbors have been targeted. I am shunned by all the other environmental groups. The hostility that is directed at the people who intervene in these cases is it's palpable, and it's totally unnecessary. And we have got to find a way to work together to meet our energy goals in a way that enhances our environment and our landscape and doesn't continue this negative divisiveness.
Okay, thank you, Annette. And thank you for compiling all the information. That's a lot of work.
It's a lot of work, and I think that what it shows is that the problem that we have is a lack of engagement with the PUC process, not too many people engaging.
Okay. Committee, any questions for Annette? Okay, thank you. Mark, did you have a witness you thought?
Tom Gardner, who's testified here on occasion, does the renewable energy projects forward, and I thought if he was going to listen to the testimony, he might have some suggestions we would consider.
Mr. Garden, would you like it?
I would love to, thank you.
Okay, have the seat. We have an actual solar developer here.
Thank you very much. I only happen to be in the building for another matter.
Your
I
time.
was asked last night if I could take a few minutes, and I'm more than happy to. Annette Smith is an adversary of mine, but I respect her very much. She put an opinion piece recently that I thought was very well written about proposed wind project in the southern part of the state. And her points, were spot on, in my opinion. And I respect both that developer and where that was coming from. So I think it was a good resolution at the end of the day. But I want to talk to you about, from a solar developer's perspective, what happens out there. Because I have been following this too closely, but I've been following something. And I know it's been represented that, hey, there's only been one case ever done by PUC on aesthetics. We're not talking about taking aesthetics out of the Act 48 process. We're just saying that interveners sometimes do abuse their right under that vision in the law. And I'll give you an example. I won't name the town, Annette may recall, because she was involved in the adversarial part of it, that I spent almost a year, hundreds of hours, meeting and speaking with my adjoining landowners and others on the periphery of it. I spent money and time, tens of thousands of dollars, doing interconnection studies. I was told by Green Mountain Power, this is a great site for solar. I was told by the Regional Planning Commission, this is a great park, a great place for the solar project. I was told by well, I guess the other thought I would say is that this was a site that had been on the market for 5 years. I was going to do approximately a third of the land for a 2.5 acre net meter solar project. It was already crisscrossed by sub-transmission lines. It was 253 yards from 2 side-by-side substations. And from those substations emanated high voltage lines, big duty ones that came out of it. We did a public hearing. And by the way, I was pursuing this at the town's behest because they wanted net metering. They asked if I would do a public hearing. I did. Didn't go that great. There were people that had some objections. We resolved all that. They asked if I would do another one. I did another one. There were 61 people there. 60 were opposed to the project at that point in time, and 1 was in favor. One woman stood up in the front of the audience and said, "You're going to ruin my bed and breakfast because they're going to be able to see your solar array from my bedroom, and I'm going to lose all my business." And she said, "He's going to ruin my business." I said, "I don't know exactly where it is, but I think I know where your bed and breakfast is. Can we go and explore after this meeting this evening and see?" We went to the second floor. We looked out the bedroom window. She said, "I can't have my guests looking down at that." I said, "No, that's not where it's going. It's way over the hill and another, half a mile away. Not half a mile, but over the hill, you'll never see it." She goes, "Oh, never mind then." But the damage was done. There were 60 people, townspeople in that room saying, "He's gonna ruin our business." Okay? But then I said to her, "But what do your guests say about all those high voltage lines going up across your boundary of your driveway?" Because at the end of her driveway were the substation. She goes, "Oh, they didn't even notice those." So it's little things like that. But after hundreds of hours of work, meeting, sitting, discussing it with all of the advisors, and everybody saying, "Yeah, we like the idea. We like the way you're gonna cite it. We like the way you're gonna move forward with this." Little by little, it crept in that, we don't want that here. One gentleman, it was near a cemetery in that town. One gentleman did an interview for NPR. He was sitting on the grass in the cemetery. And he said, exactly, he said, "That solar project will ruin the solemnity of this space." As a logging truck went whizzing by him, 50 miles an hour, all kinds of noise. And my little solar project, 200 yards down and behind, would have been ruining the solemnity of that cemetery. You can't make this stuff up. But after all that work and all that time, forces came in to say, and I'm gonna say influencers came in and said, "You don't want that in your backyard." Small businesses, a bank, a massage place, a printer, former gas station. You don't want that behind you. You don't want to be able to see that. And little by little, it all changed. maybe I hadn't reached out to everybody I should have, because I learned later, there was a self-proclaimed mayor of this little section of town. And I think he's the one that maybe turned things against it, but even with all that money spent, even with, GMP telling me it was a great site. I remember now, it was A&R, the Wetlands Division. It's a great site, Tom. It's one of the best we've seen. GMP telling me it's a great site. You should do this project. I decided I'm gonna drop it. I'm gonna drop it. PUC, DPS, it never came to the light of day. And that's over a year of work and tens of thousands of dollars. And I've got numerous examples of that. I have one that I started in another community on the west side of the state. Everybody was in favor of the site. It's gonna go on a farm field, take 2.5 acres of a farm field and a well-connected adjacent abutter sat up high, looking down over his farm field, objected to it at a public hearing. I think maybe it may have been the Regional Planning Commission, and I was going for a site designation, and said, you know, it's gonna ruin the value of my property, because I'll be able to see that when the leaves are off the trees from all 37 windows in the back of my house. All 37 windows in the back of my house. Later, I was in front of the that town's select board. And a representative of the Regional Planning Commission came in and said, we'll back you if you want to do that project. Because they were so irate that somebody had that kind of a sense that it wasn't that important. And I said, you know what? Elena and I have already agreed, we're not gonna do that. We're not gonna push it. Why? There's a lot of fields out there. I've never done a project where I had to cut trees. I don't like the idea of removing trees. I just don't like that idea. But I looked for green fields. I've worked with a lot of farmers who've reached out to me and they said, my children don't want to farm. I'm the third generation. There's nothing left, you know? And you walk around the farm or you drive on their ATV or the tractor around the farm, dilapidated barns, dilapidated farming vehicles. The cows are gone on so many of these places. They're forced to say, I'll lease out this land to the gentleman who's gonna grow corn for $100 an acre. And I come and I say, I only need 2.5, I'll pay you for 3 acres, I'll pay you $1,000 an acre. And you know what? I'm like, all of a sudden, this project isn't as important to me as it is to them. Because this gives a 70-year-old farmer with bad joints and not a whole lot of maybe savings to say, you know what, that's kind of important. This would be great. So I use a farm field. I use an old gravel pit. I am presently in the stages of evaluating an uncapped, unregulated, unlined former municipal landfill. And I'm doing my due diligence on what needs to be done to clean that and make it right, because I will literally buy this land. It's on private land. And generations ago, they leased a portion of it to be used as the adjacent town landfill. I don't want that obligation. I hear brownfield, I run it, but the state DEC is saying, no, we have programs in place. We have hundreds of these that we would like to clean up. So I've gone through the step of funding the first phase assessment to see if I can get what it would take to get it cleaned. The state is looking at my application to fund the next phase of assessment studies. And in the meantime, one of my primary concerns is I've been doing all this, but I haven't gone to see the few residential neighbors who abut this. And I know from reading things that I can run into a lot of trouble when an adjacent landowner says, you know what, we like that green field. Yes, but you know it's a brownfield. No, that's okay. We like that green field. That's a status. You have an intervener status. That's your argument. And that will hold water because you were there before me. Even though I'm trying to do a 500 kilowatt net meter project on a brownfield that I will clean, I will own. It'll be adjacent to the greenfield portion of the private property where I'm proposing to build affordable housing that will be powered by the solar array. They may not be able to use all of it, but I'm already in discussions with a low income developer, nonprofit, that will utilize some of the other credits. Now, to some adversaries, they would say, listen, you can't be building this stuff so far away from load. Well, no, literally, some things, some developers do, but in some of your net meter customers, maybe, from a town away or 3 towns away. But for the most part, when I build 2 500 kilowatt solar projects for General Electric Aviation, number one, I've taken 4 years to convince them it's worthwhile to sign a 20-year contract, because they tell me from day one, we won't. I'm doing that in a community, it's not right on their property, but I'm within 2 miles from 2 of their factories. And you've got one of the largest employers in the state who is saying, we want to do this. The red door is coming up for a vote. The last time I was in this, maybe in this room, was when that was originally being debated. And I was in here because I was trying to surreptitiously say, can we make a rule where GE Aviation, one of your largest employers in the state, can net meter off a 5 megawatt project, which nobody could do except for maybe Global Foundries at the time. It never went anywhere. There was too much focus on the res. We did 2 500 kilowatt projects. It was less than 1% of their load. They're building airplane engine turbines 24 hours a day, 1% of their load. It wasn't about making money. It wasn't about saving money. It was GE trying to say to Vermont, we get it. We want to give back. We want to keep these jobs. We want to preserve what we're doing in the state. We could easily move all these jobs to New York and save money on taxes, save money on electricity, save money on everything. But they don't. They want to demonstrate that we're here to help with jobs, the environment, etc. That's, some developers have a little bit of a conscience. I think I have a conscience. I've looked at many a site that Greg will never know about and said, should I build here? There's a nice house up there. It looks like somebody has some money, and they may not like to look down here. And I've made I made offers, and then I've withdrawn offers. Because I said, if it was my house, what would I do? Would I want it there? I don't oppose, so I don't think it industrializes the landscape. I am told over and over again, I'm industrializing the landscape. I realize if I go forward with this brownfield, just a few exits south of here, I will be accused of industrializing the landscape, which is, for the past, since 1970s, has been a greenfield. No one knows what's in it. All knows that the water coming out from underneath it is orange. We can fix that.
We're gonna have to wrap up because.
And I want to make one last point,
Okay.
because you're asking about a compromise. What I think is that if I want to do a solar project on a farm, people have to understand that, like I just finished a standing offer project on a 63-acre farm that grows corn for the cows. It's not for human consumption. No farming I've ever built on has grown something for human consumption. One. And number two, that landowner, that revenue they'll get from that is incredibly important. Number three is if there's some kind of commercial, agricultural, or other use now going on that land, the adjacent landowner is already used to seeing tractors, trucks, all kinds of manner of those things. And they shouldn't have the ability to say, the aesthetics is going to change. I understand where you're coming from. I think if you're a resident, you're home, and somebody's proposing something next door that's never been used for anything commercial, and there's no other commercial within your view shed, you should have it to be in your status. But maybe the compromise is not if it's in some kind of, agricultural commercial use. Maybe there's a carve out for that. And thank you very much for your time. I
Okay,
really
that's a
appreciate it.
good suggestion.
Thank you.
Especially on a brownfield.
Okay. We are going to change focus, and we are going back to the deductibility of deer carcasses as donations. You didn't do this yet. Okay, come on up. Really old now.
We're dealing with the tax implications of donating. We're dealing with the tax implications of donating.
Yes, if it would be possible. And Will, how did you find it? Okay, all right.
Well, good afternoon, Madam Chair, members of the committee. My name is Greg Faber. I work for the Public Utility Commission. I'm here on S-236, in response to questions raised during my last testimony, I believe, about how many projects were denied.
Yes.
Okay.
And I guess right now, if we do what this bill says, is there adequate protection for the abutters, for the neighbors? I mean, we're walking a thin balance here
Yeah,
because.
it's a good question, and Senator Brock raised the same question from Mr. Walsh. I guess I don't agree with Mr. Walsh's interpretation of the amendment to the statute. When you line out that word aesthetics, we're going to interpret, we being the PUC, we're going to interpret that as you telling us not to consider aesthetics, okay? Because, and if we didn't do that, there will be many lawyers out there who repeal all our cases the second we try to apply that criteria. So if your intent is to have some lesser application of it, like Mr. Walsh was suggesting, you should be very clear in the drafting of that. You should say, we're lining it out here, but PUC, you shall consider it in a lesser way. I don't even
You
think.
should pay a lot of attention to what we said. Because I think that
We do pay attention to that, yeah.
I just want to make sure I understand the statement about people who would be lining up to revisit their project.
No, they would, if we decided, once you line that out.
Yeah.
And then we decided to apply the criteria anyway,
Oh,
there
I
would
see.
be,
Yes.
lawyers would.
Okay, I thought you were saying everybody belonged.
No,
Yes,
I'm not saying that.
What I'm starting to hear is that when community members intervene on the grounds of aesthetics, which really is the only one they can do, traffic and public safety are really more town things.
People do, intervene on orderly development, if the town hasn't come in.
Okay,
And from Annette's testimony, see, the towns don't come in every case.
yeah,
So many times community members will come in under orderly development.
okay. But I understand when people intervene, and it sounds like aesthetics is the thing that.
They almost always intervene on aesthetics, yes.
That, not that they win, but that it slows down the permit, because you have to give them time to testify, and they have to bring in people to testify. And that by slowing down the process, it costs the developers time and money, and therefore it's more expensive for them to do solar projects. I think that's, the bill is trying to limit that intervention so that things can go through more quickly. I
Right.
think there's some concern that going more quickly might miss, I think Annette was saying there are only, few site visits. And, if you don't do the site visit, and how do you know what the aesthetics are? And I think you said, if we line it out, you won't touch it.
No, we wouldn't consider it. So, yeah, so people intervene on aesthetics, certainly, neighbors do. However, most of the work with these larger solar projects, and again, these are $1 million projects, as you've heard. The smart developers, like Mr. Gordon, he would go out and speak to the neighbors beforehand and say, well, what's it gonna take for you not to intervene or oppose this
So I
project?
need to put up the,
Yes, you're gonna put up, you're gonna plant trees, you're gonna put up, shrubs and things like that, or you're gonna remove it maybe, out of their direct view. So maybe they don't intervene in the process at all. Does that cost you as a developer? Sure it does. But is it less costly than having the person intervene in the case and involve litigation? You have to weigh those things.
They get better projects.
Exactly. You're gonna have better cited projects because of that threat of litigation from the neighboring landowner. But obviously, it's up to you folks to balance that.
Senator Gray.
Thanks for coming in. It's always good to get these details sorted out and. Mr. Ashley Walsh was talking about, people, community members could still raise concerns about aesthetic criteria in like sort of a noticing comment. Again, I don't know exactly what you end up calling it. But
Public comments?
yeah, the public, thank you, in the public comment period. Can you explain how those public comments are fed into the process and how they influence or don't influence the proceeding?
Sure. So, we have public comment periods. People will send in concerns, through electronic document files. Those comments are used by the hearing officer or the full commission to basically, outline questions if other parties aren't raising those concerns already. So let's say people write in, comment on aesthetics. And no other parties in the case have raised that. However, if you removed aesthetics from consideration in the first place, we would say, well, thank you for your comments. That's not something we can manage.
Sure.
Now, if they had raised concerns about, let's say, traffic impacts that no one else had raised.
Yeah.
We might ask those questions of the petitioner during the proceeding.
Yeah.
If there is one.
Yeah.
So that's basically how public comments are used. They are not evidentiary.
Right.
They're not part of the evidence in the case,
Yeah.
but they can be used to form questions.
Okay,
Um,
thank you. Helpful, because I remember on Addison Natural Gas Pipeline Project, there were many public comments over a period of like years. And some people were disappointed that their questions didn't seem to lead to, the outcome they wanted, but I just wanted to make sure I understood. It informs the officers hearing the case on what they might want to check in on.
right. Right. Has anyone addressed that issue in the evidence? And maybe they have.
But if we take out the aesthetics criteria, you said, too bad if you sent
Right.
anything and said, there's glare coming in my front window and I can't sleep and whatever.
Yeah.
You couldn't-
So it's similar in a telecom case. We often get public comments about radiations,
Oh, yeah.
electromagnetic frequencies. But that's not something we can consider in the case.
Right.
So people can raise those concerns, but it's not very helpful to it's not gonna be in the evidence. We can't really do anything about it because we're federally preempted. So,
Okay, Senator Ron Hinsdale.
So when I think of compromise, and I know, we're going through this with housing too, so I know I'm asking something challenging, but I look at, for example, when we talk about shelters or motels, we're saying you can influence a lot of things, but you can't say it can't be used for this. So in my mind, it's one thing to say, I want a mediation process, or I want some way to make sure that they've taken into account my concerns about glare or eventual tree coverage, et cetera. But they can't use they can't have an ultimate bludgeon with an aesthetics concern to say solar does not belong here.
okay. Well, aesthetics is just one of many criteria that we use.
Mhm.
And of course, the PUC can say, even though it fails this criteria,
Yeah,
we believe the project's in the public good ultimately, and still approve that project.
right.
So we do have that flexibility, unlike
Right.
Act 250, they can't do that.
Right. What I think I'm hearing is that people want to make sure they still have a conversation about aesthetics, that the joiners are able to say that glare would go right here in my kitchen window but that using it as a tool that adds a lot of delay and cost and essentially gives us a policy choice where we're saying solar panels are ugly. It isn't necessarily in our best interest, that it should be a criteria for some kind of mediation that everyone's operating in good faith to address aesthetic concerns. But that it's an ultimate trump card for neighbors feels like the issue. Does that make sense?
Yeah, I don't think it is an ultimate trump card. They don't have a veto power.
Yep.
They get to intervene as a party on aesthetics. Doesn't mean they're going to prevail. And in fact, if you look at the information,
Yeah,
only one case has ever been denied on those grounds.
right.
Out of the last 300 I looked at, so.
Right, I can make one more kind of question comment. It, you know, based on what our last witness said, just this. The solar developer having to sort of go around by themselves and make sure no one's concerned. It just feels like a kind of costly and unfortunate process. Is there any way to create a more streamlined approach to, you know, making sure anyone who has some kind of party status speaks at a certain time and then can't appeal?
Well, there certainly are timelines for appeals,
Yeah.
for filing a motion to intervene in the
Mhm.
case and try to become a party. So
Right.
there's strict timelines on that.
Yeah,
However, does that prevent a person like Tom Garden from going around and talking to neighbors before he's even filed the case?
right,
No, he's doing his due diligence. I don't know how to prevent that.
Yeah.
I don't know.
And
Why would,
can a neighbor appeal based on aesthetics? Can they appeal a PUC decision?
can a party in the case, any party in the case can appeal our decision?
Okay. Have we had instances where neighbors have appealed and really tied it up? Doesn't sound like a lot.
A case that's been approved over the objections of a neighbor that intervened on aesthetics and then them appealing.
Yeah.
I'm unaware of that. That's tough one. I have to go back and look, but I don't think so.
I think that's what we're dealing with in housing is appeals that can.
No, and again, appeals don't stop the project in our case. Once you have your certificate of public good from the PUC, you can go ahead and do your project, you know, at your own risk. The Supreme Court could reverse this later on, but
Okay, I had Senator McDonald, then Senator Gray, and we are now a half hour late. For our next witness, so.
so just one comment,
Yeah.
short comment. Tom, the last witness does what, you know, Vermonters do. It's a neighborly thing that he's doing. He doesn't have to, but and if we have a tradition, usually of people talking with their neighbors before they do something. I wouldn't want to discourage that. Senator Chittenden has brought up the one that worries me, which is the Route 7 corridor, where it's solar project after solar project after solar project, and it's not good politics for us to subject the tourists to solar project after solar project after solar project, because they happen to have the wire that's able to accept it going up Route 7. Could we deal with that, or is that we're just stuck with it? To deal with the a bunch of them together in one location, is that? Well, every quarter mile, there's another one. Yeah, no. You could be going across the state sideway, you know, east to west, and those roads are less. It's not the same thing. Route 100 is similar, going up through the Waitsfield and that area, where they're one after another, and you go, enough.
Yeah, but that is the least expensive place to do, because you don't have to do a road and you've got 3-phase power, so you don't have to string it out. And I think that's the kind of balance we're looking for. If aesthetics is really the one, if you can't consider it, we strike it out, then you can't say it really would look ugly if we did this.
Right, and you really couldn't look at a conglomeration of projects either, because you're talking mostly about the aesthetic impact, and the aesthetic impact of more of them, you wouldn't be able to look at that either. So you're kind of going the opposite way in this bill, but. the Route 100, the Route 7. I find bothers me, but the rest of them, I think they work a lot of, they work things out ahead of time and they're not. They're neighborly attempts to do, to get renewable energy, which we say is our goal, and working fairly well. I mean, that's what that.
Senator Bray, and then we're gonna have to end.
Having been living in New Haven when all this stuff was going on, so, towards the end, well, two things. One, we did Act 174, try to give towns a voice and then help them steer projects. So one question I have is, have you seen that work? It was a construct, an experiment, right? Where we're like, does this influence where things land? I don't know the answer exactly. And I know on Route 7, people got sensitized to that issue, and then subsequent projects moved back over a rise or behind the tree line of a second field back. So it wasn't probably the cheapest place to build because they had to drop power and run it in. But they did it anyway because people in town were getting upset about stuff. And it was
They've been adjusting to it.
it was like that neighborly thing. Well, it was the people who really lived there who were developing versus people who came in and put something, but they didn't have a town connection.
Okay, so
But anyway, so we did that, our work on siting and giving towns more influence, if they had that improved energy element. The whole idea was proactively avoid those things, steer projects to where towns want them. I don't know if that's helping or not.
Well, we did just have a project in Bradford withdraw because of town and regional planning commission opposition. That was water and sewer issues where the town had planned to use water and sewer on that line. And the project was sort of making their investment null and void
Right.
after they had plans to have that be part of this, the neighboring strip development.
and I think that's things we want to consider. I'm gonna have to wrap this up because I've got about 4 witnesses in line, and Will has been sitting here for over a half an hour.
Are they 4 witnesses on your record?
No, there's
Okay.
one witness from
Just
Deer
curious.
Carcasses, and I'm sure Will is
Thank
really
you.
excited to talk to us about that. This is F 166. Allow the donation of legally taken game to be a charitable donation under Vermont's charitable donation law. I think we're one. I can't see this being used a whole lot of time, but just wondering, what's it gonna do to the tax department, and is it possible?
Sure, Will Baker, Assistant Attorney General, assigned to the Tax Department. Happy to be here. So we took a look at this and initially we were looking at whether it was necessary. In other words, would such a donation be acceptable under the charitable donation law as it is today? And then what, what if not, what does it do? And so our answer is, just a step back, that there's a 5% tax credit in Vermont for charitable donations. You don't have to itemize like you do federally. It's just right there on the Vermont income tax return, and it's capped at $1,000 of tax credit. But otherwise, it simply piggybacks on all the federal rules about qualified charitable contributions.
Things have to be federal.
Yeah, if it's okay federally, it's okay for your Vermont tax deduction. So we think that it is a little bit expansive from the federal rules. And the reason for that is because federally, you can donate money or you can donate tangible property. Either is fine. But federally, you can only, it's only deductible if you donate it to a charitable organization. And that's a broad definition. It could be a nonprofit organization, like a fraternal organization, a government entity, federal, state, local, whatever.
A food bank.
Food bank, yeah, nonprofit organization, yeah. So that's all fine, but it's not person to person. You can't.
Yeah, I think
donate
this
person
is
to-
looking at probably the fire department's game dinner, and I donated a deer. We got down to how much can you subtract for a couple of squirrels for squirrel food? Red squirrels, I mean, a deer, there seems to be a market value for,
Mhm.
but who sets the market value for a couple of squirrels or rabbits?
Yeah.
Rabbits get sold, I guess, so they have a market value.
But the new market for appraisers.
So I think if you donate, game, lawfully taken game to a food bank, today, that would be perfectly acceptable federally and under the law. So that's fine.
But where would you get the value?
That's a good question, but there are all kinds of federal rules about kind of.
The value
all
of
those
squirrels, for example.
donations.
That's a rule.
I mean, in the first instance, it's the taxpayer's obligation to report that value.
I think they got $600 right now.
So we
For a
would,
whole year.
you know, you would report what you would report, and then, of course, it's all subject to audit, tax department.
I mean, that's the question though,
Yeah.
when you subsidize goes to the tax department. Is the tax department able to evaluate those things?
Well, we are to the extent that we are for any other charitable donation. I mean, we have a charitable tax credit, and all those federal rules apply, and Vermonters are taking that deduction. And so, yes, we would, if something seems unusual, we might take a look at it and we might adjust that value.
Like taking a bag to the Goodwill is very subjective
Yes.
right now,
But with a value, Goodwill, there's a value for used shirts, there's a value for used trousers, is there a value for used squirrels?
well, there's a value for deer meat.
There
Yes.
there might,
That's the
Maybe,
market.
I just, that's what I'm asking.
believe it or not, there
Look at
might,
the
there might be a value for perishable food, for meat, I don't know. But
Then we get into butchered or unbutchered.
but the reason why it's expansive is not so much that it's lawfully taken game, but it's that second reference to Vermont law, donated pursuant to the requirements of Title 12. And so that section is actually addressing donations to a charitable organization, but also person to person. And so we read that as allowing the donation of lawfully
Give
taken
to my
game.
neighbor and write off $600.
Yeah, and so that's why we think it's expansive. And it's an extension, an expansion of the federal
Of
rules.
the federal rules,
Yeah.
okay, so we'd have to,
Thinking in terms of the value, figuring out the value, the way most deductions work, the taxpayer decides what the value is.
I have no idea what my 10-year-old jeans is in.
And then if the taxpayer might get audited and the tax people might decide you've overstated. And then you have a discussion and probably the taxpayer would want to make the case. But, and probably what they would do is there are restaurants that serve
Oh, yeah,
farm raised venison. I mean, what does venison go for by the pound?
yeah, I think that's,
And we, I suppose, could do that. We could have, get witnesses, you just find out. And write that into the,
I think we might be fine. Because it sounds like it's allowed now if it's to a charitable organization. So if we tightened it up so that it wasn't person to person, we would be in line with the federal law.
If it's not desirable to have person to person donation be subject to the tax credit, then I don't think you need a bill at all. Because you can donate food to a charitable organization and you get the tax credit.
Somebody must have been told they couldn't, which is what inspired the sponsor to do it.
Or they wanted to donate meat to an entity that wasn't a
Yeah,
nonprofit organization. Maybe it was,
I think we were told that your local fire department would be, since it's an arm of government, but perhaps your local fish and game club wouldn't be a charitable donation if you were doing it to the game dinner. But,
yeah, I don't know the like the
Okay.
legal status of a fishing game club. If it's a nonprofit organization, that would be fine.
okay, all
Yeah.
right.
So, we discussed this with the tax commissioner and he is neutral either way. In other words, with the bill as it is, so it's person-to-person donation, or without the bill, obviously.
Okay, I will talk to the sponsor and explain to him that unless it's a person-to-person donation, and you can try to exclude that you think the tax department thinks it's legal now.
Yeah.
And,
Well, it's not clear to us whether the thrust of the bill was to make sure meat was okay, or make sure person-to-person donation was okay.
well,
But
that,
meat is okay.
the meat is fine.
That's right, if it's to a nonprofit organization or a government entity,
Okay,
fraternal organization, et cetera.
yeah, so I will see why that's in, and it may just be somebody talked to the wrong person and was told they couldn't donate their buck to their favorite charity.
Mhm.
But they couldn't donate it to their grandmother. Okay.
If you took it to a social event, would that be a meet and greet?
Oh,
Oh,
It's only Tuesday.
okay, we are getting over our heads here, so thank you, Will. I think that gave us what we need to
Okay,
decide if we, that's probably the easiest.
yeah, there are some others that are,
If you have quick enough thoughts about unnecessary bills, please let us know.
Yeah,
okay,
okay.
Thank you.
Thank you. Okay, we're only 15 minutes behind, that's not too bad. I don't know if FX is out in the hall, we told him we were running a little high.
Told me he was watching the live stream. so
He's
I
watching a
imagine
live
you're about to see
stream,
him
so
walk
I
through the
should
doors.
expect him to materialize. Any minute, why don't you take a 5-minute break just to stand up and stretch your legs?
Oh, just start the Zoom.
Does anyone